Hi, I'm Rob Carolina. This is one part of a multi-part introduction to the Law and Regulation Knowledge Area of CyBOK. The Law and Regulation Knowledge Area is one of 19 knowledge areas in the entire project. The webinar that introduces this knowledge area is pretty long, and so I decided to break it up into 15 constituent parts. You are now about to listen to one of those parts. If you haven't already done so, I would recommend that you go back and listen to the introduction. It's also labeled Part 0. That'll help you understand what's about to happen. Alternatively, you can listen to the entire webinar as a single file. So without further ado, let's listen to this part. Let's look at some introductory principles of law and legal research. You have to remember that law is dynamic. Yes, law influences society and members of society, but people in society also influence the development of law. Law changes, laws change, rules change over time. Secondly, there's always a degree of uncertainty in just trying to figure out what the law is at a given time. There are a wide variety of sources where you find the law and also different methods of how to interpret what you've found. Finally, when we're trying to apply law in a cyber environment, remember a couple of things. Law is about addressing the responsibility of persons and the disposition of property. Secondly, law is territorial. It's linked to geography. It is a reflection of society. Third, there is no such place as cyberspace. It's not a territory. You have to bear that in mind. And finally, increasingly, I get this question, and the answer is no. Laws do not recognize artificial intelligence as a separately defined person. I have put some references to some interesting articles that suggest perhaps about why that should or should not be done, but for the time being, the law does not recognize artificial intelligence as a separate person. I can think of only one slight counterexample, which is just not applicable for anything we're talking about. I've also, over the years, working with cybersecurity experts, realized that there is some confusion when a lawyer talks about trying to prove something. In a discussion with one of my favorite mathematicians, what came out was this, is that in mathematics, to prove something means to establish as a logical necessity that something is undeniable, to establish a truth beyond dispute. So here we have the Pythagorean theorem, for example. It is a theorem. Having said that, there are a number of well-known mathematical proofs of that theorem. You can prove this to a logical certainty, absolutely beyond dispute, a number of elegant proofs. In law, on the other hand, when we say we're going to prove something, we're talking about using permissible evidence to persuade a tribunal of the correctness of a disputed issue. In looking at that definition, you should immediately realize a couple of things. One of them is that some uncertainty remains inevitable. And the second thing is that we're trying to persuade correctness up to a certain degree. So an example of the proof we're talking about here comes from the Aaron Sorkin film, A Few Good Men, where Lieutenant Caffey, of course, is arguing at the top of his lungs with his fellow lawyers about, what he has to prove. Oh, Colonel Jessup ordered the code red. Great, you have proof of that? It doesn't matter what I believe, it only matters what I can prove. That leads us neatly into a quick discussion of standards of proof. And there are quite a wide variety of these things, and I've put standards in quotation marks, because these are anything but standardized on a global basis. You find that although these phrases and words are routinely used by different courts in different locations, they can be interpreted in slightly different and sometimes surprising ways. The one that's most familiar, or two that are most familiar, I suppose, would be preponderance of evidence, which is to say greater than 50%. And that's normally the standard used in non-criminal courtroom actions. If I can prove my case, if Alice can prove her case, and convince a judge that it's more likely than not that Alice's version of events are correct, then Alice will win in a civil claim against Bob. Whereas if it's the state of Alice trying to convict Bob of a crime, then the state of Alice normally has to prove guilt beyond a reasonable doubt, or some other form of words that conveys a similar type of meaning. You can't really map these one-to-one onto percentage degrees of certainty, so that's all approximate. Finally, I did want to introduce the idea about assessing legal risk being different from understanding legal rules. I find this is an area of confusion routinely when students come to my course from STEM subjects. Very often I'll ask the question, what is law? And a typical response will be, well, it's a series of rules that we must study and comply with, or a series of rules that someone's going to enforce against us. Well, there's a lot more to look at in terms of assessing your own legal risk from a possible legal action. So here I've laid out different ideas to try to get out the idea that you have to separate these into different categories. So the P term, Alice's relative ability to prove her case against Bob. Well, the D term might then reduce the risk because Bob might have some affirmative defenses. Third, something that's very often overlooked by non-lawyers is, well, forget about the rules for a minute, what's the punishment? Or what do we suffer as a loss if Alice wins her case? So if there's very little cost, maybe that will influence our analysis of legal risk. And finally, in the X category, something that I don't really deal with very much in this knowledge area because it's too difficult to get into, are a whole raft of additional factors that will influence this risk calculation. Willingness, resource capability, things of that nature. Let's have a look at your